Now it is time for the panel discussion. The topic of discussion is institutional arbitration and insurance dispute resolution. Mr. Masood Wahab, Senior Advisor, AIIRM, would be the moderator for this discussion. Mr. Masood Wahab has had a long and successful stint of over 40 years with Oriental Insurance Company. He has worked in the technical, grievance, and training departments in various capacities, having retired as the regional manager in 2018. While in service and even after retirement, he has been involved in education and training activities for Oriental Insurance Company, as well as has been teaching and training insurance as visiting faculty in institutes like Xavier Institute of Social Studies, Ranchi, National Institute of Financial Management of Faridabad, Institute of Chartered Accountants of India, Delhi, and Jamia Hamdard University, New Delhi, CBI Academy, Ghaziabad, etc. At present, Mr. Wahab is the Senior Advisor, AIIRM, in the honorary capacity. He's a Director for AAF, that is ASEAN Arbitration Foundation, and he's a member of the Governing Council of ACDR. Mr. Masood Wahab.
Thank you. Thank you very much, Mrs. Vandana, for my introduction. Justice Nageshwar Rao sir has beautifully laid out the need for institutional arbitration, and he's also stated about the ad hoc arbitration, the pitfalls of that. And in his talk, he has enriched us with the knowledge of arbitration, not just in India but outside, especially in USA. We are very thankful to him for enriching our knowledge and laying the ground for this panel discussion. Ladies and gentlemen, and all my senior colleagues, faculty members of AIIRM, the participants of the first batch of insurance arbitration certificate course, participants of the second batch, as well as the participants of the new batch, third batch, which is going to start from 25th of this month, and all the guests who have today joined this webinar. I welcome you all to this panel discussion in which we have four eminent personalities who will be giving their view, discussing their views on the need for institutional arbitration. I'd like to introduce them, and I'll request them to kindly join us first. So I'll request Justice Hariprasad, Mr. Niraj Kumar, Mr. Vijay Srinivas, and Mr. Amarjit Singh Bedi to kindly join us. Kindly switch on your cameras and your mic, please.
Yes, Mr. Masood, I am very much here. I think I'm audible to you.
Yes, sir. I can see you also. You are audible also. Thank you very much.
Thank you. Thank you.
Yeah, good afternoon, Masood. I am here. Niraj Kumar.
Good afternoon. Good afternoon, sir. Good afternoon, Mr. Amarjit, sir.
Good afternoon, sir. I am here.
Mr. Justice Hariprasad.
Yes. Yes, I'm here.
Yes,
yes, I'm here. I can hear you.
I can hear you, sir. I'm not able to see you.
I have switched on my camera. Yes. 1 minute. I'll do the exercise once again.
Yes, sir.
I think I'm visible now.
On my screen, you are not coming. There may be some problem, sir. I'll just check up.
You're not visible, sir. You're not visible, sir.
See, Pratap, I'm able to see. I'm not able to see Pratap. I can see Masood and other learned panelists here. Actually, I don't know. Is it my problem or the other problem?
Sir, this is your camera, sir. I think your camera is not turned on, sir.
No camera, because I see my image in the chip, in the what you call tile.
Right, sir.
Technically, I have switched off once and then again restarted once more. I'll do that. Aji, I think I'm not visible. No, come on, check here. Can you see me now?
Maybe, sir, it will come. No, we cannot. At least I cannot see you.
No, sir. Not visible.
And visible Allah എന്ന് പറയുന്നു. I'm not visible to them. 1 minute, please.
Yes.
So,
ഞാനിവിടെ ടൈലിൽ കാണുന്നുണ്ട്, പക്ഷെ അവർക്ക് കാണുന്നില്ല എന്ന് പറയുന്നു. പാനലിസ്റ്റിന് ഞാൻ able to see me. Can you see me now?
not yet, sir.
No, sir.
I think something wrong with the camera in the computer.
It's on.
Computer, പക്ഷേ in my screen I am able to see myself. That is why I am not able to.
I think we'll proceed, sir. Because
Okay, we'll proceed. Of course, I'll remain behind the curtain and I'll speak. No problem.
Right.
Thank you very much, sir. Thank you for the permission to start this. I once again welcome all the 4 eminent panelists for agreeing to be there in the panel and to discuss on this topic, need for arbitration, institutional arbitration. I'll take the opportunity of introducing them. First of all, I'd like to introduce Justice A. Hariprasad. He is the former judge of Kerala High Court with a vast experience and expertise in the field of civil, criminal, and constitutional laws. Having served as president of the Board of Governors of the Kerala Judicial Academy, chairman of the Kerala High Court Legal Services Committee, and as member of the High Court Rules and High Court Services Rules Committee. They're presently now in Delhi, and I believe he'll be available the legal practitioners for all. And again, very thankful to you, sir, for joining
Thank you.
us.
Thank you, Mr.
I'll now introduce Mr. Niraj Kumar, my senior and my boss also from Untitled Chapter. He is at present a consultant and advisor, Horden Insurance Brokers. Formerly, he was general manager and director of Untitled Insurance Company. And he was also a former CEO and MD of TAN's India Insurance Company Limited, Tanzania. He joined the insurance industry as a junior officer in GIC in 1978, and then posted to National Insurance Company, where he rose to very senior rank, and then he got transferred to Oriental Insurance, from where he retired. We have Mr. Vijay Srinivas, my friend and colleague. I will say my batchmate also. At present, he is an insurance consultant, a trainer, and a freelance writer also. He writes beautiful poetry. He is a retired director and joint additional charge CMD of United India Insurance Company, with a stint of 3 years in between as general manager in National Insurance Company. He joined the insurance industry as a directorate officer in United India in 1981. And amongst all of them, the youngest, Mr. Amarjit Singh Bedi, he, with his 20 years of experience in litigation, he's a gold medalist in the Advocate on Records exam conducted by the Honorable Supreme Court of India. So he's basically on record advocate of Supreme Court of India, specializing in commercial litigation, giving legal advices to varied clients, providing corporate advisory and acting as a strategic advisor to senior management, including MNCs. He's author of the book on environment and pollution laws. And he's a visiting Delhi Police Training College. He's visiting as a guest faculty there. A guest lecturer on cyber laws and crimes. I welcome all of them. I'm very thankful to them for joining us in this panel discussion. And to begin with the panel discussion, I'll have the permission of all of you to. I'll be putting a question, and thereafter I'll be requesting your answer, whatever views you have on that question. So we'll be doing first round. Depending on the time, we will go into the second round. And all the people who are listening, who are attending this panel discussion, all our guests, all our participants from the groups. If anyone has a question which they would like to put to the panelists, they will have to put it in the chat box. So kindly write your question in the chat box. I'll request Mr. Dr. Mallikarjun to kindly have a look at the question. And if the questions are like, we can use that question to the answer, and we will put that question. But that depends on the time. So first, my question I'd like to put to Justice Hariprasad. So there is a perceptible shift in emphasis from ad hoc arbitration to institutional arbitration. What are your views on desirability of this move?
Yes.
I'll repeat the question, sir. Should I repeat the question?
No. I have the question. I have the question. I understood the question.
So,
Thank you, Mr. Masood. Thank you, my dear friend Pratap Venugopal, and all esteemed panelists, participants. Thank you for the opportunity, first of all. After hearing Mr. Justice Nageshwar Rao, I think the question pales into insignificance, because he has covered all these areas very elaborately. We have heard it at length. The advantages of institutional arbitration and the advantages of ad hoc arbitration have been, he has enlisted all those matters in detail. But in a micro level, probably the institutional arbitration, it's my perspective, of course. In a micro level, probably I would say that ad hoc arbitration will be more convenient, or rather more feasible, provided the parties going for ad hoc arbitration have an idea about the process of arbitration itself, because they will have to find out an arbitrator by themselves, maybe either taking recourse to Section 11 of the Act, or by some arrangement, private arrangement. And if they are able to agree on an arbitrator, that will be easy. And they can formulate a procedure of their own for this conducting arbitration. And these are areas, probably they can reduce the expense. So these are the some advantages of ad hoc arbitrations. Whereas, if the magnitude of the dispute are so complicated, wide, or rather it involves some technical issues, it's always, in my view, always better to go for institutionalized arbitration, because you get a panel of experts in various domains, and you have a set of rules governing the arbitration and the procedure in the institution, so that people will be nobody will be taken by surprise, or nobody will be taken aback by the when the arbitration proceeds. And you will have all the infrastructure available, including the staff and the dexterity in writing awards in a flawless manner. Now, these are the advantages of institutionalized arbitration. And of course, a slightly higher amount of cost may be involved, because the institution also has to be paid. So in my perspective, depending on the nature of dispute, depending on the attitude and the wish of the parties, if the disputes are very simple and it can be decided by an impartial person chosen by themselves, because arbitrator is a private judge, they can decide on who has to do their arbitration matter. If that is decided and they are able to agree upon the procedure, and they are to some extent well versed in the procedure, then they can go for ad hoc arbitration. But if complex issues and what you call where skills are expected from the arbitrators, or if you are not able to agree on these things, then probably institutionalized arbitration is good. As pointed out by my Justice Nageshwar Rao, the credibility of institutions are also very important for going for arbitrations. So if that is assured, I think normally in a growing scenario, in a what you call this commercial activity, especially institutional arbitration will be more feasible. That is what I feel. But in a case where say for example a partnership, a business partnership where 2 or 3 persons do business and they what you call starting distrusting each other, then probably that is not what can be resolved by an ad hoc arbitration. That depends on the nature, according to my perspective. I think I can cut short my point like this, because having heard Mr. Justice Nageshwar Rao, he has pointed out the advantages and disadvantages of both these systems of arbitration. And therefore, depending on the nature, I would suggest the party to go for either ad hoc arbitration or institutionalized arbitration. But institutional arbitration has an edge over the other thing, for the reason that there is an infrastructure and set rules and the facilities for doing that. So that is my point on this topic.
Thank you, sir. Thank you very much, sir. You have thrown further light on the matter, sir, after Justice Nageshwar Rao. You are very much enlightened. I'll now be putting a question to Mr. Niraj Kumar. Sir, being a senior executive officer, or a senior executive officer of a PSU insurer, how do the senior executives of PSU insurance companies view arbitration as a means of dispute resolution? Was the environment conducive to ADR in dispute resolution? This is the question. Should I repeat it, sir?
No, I have understood the question, Masood. Your question is basically in 2 parts. So I'll address the first one. During my tenure and as per my experience, arbitration are far and few, and particularly and mainly for large clients and for large claims, we have seen arbitration. But all said and done, insurance companies were never very enthusiastic about the process of arbitration. And it was not only so in my company, it was the impression across the PSU companies, as far as I know. And though I've been retired for the last 6 years, I understand that as of now also, the position has not changed much. There could be many reasons for this, but one reason that we felt was that most of these arbitrations came after a judgment or an AIIRM directive or something, that even after a full and final discharge, the clients were able to go for arbitration. So there the insurance companies felt that it's something forced on them to reopen the case which they, according to them, have amicably settled it. So and then as far as the procedure was concerned, the whole process was fine, and it ended fast, so there were not many surprises. But there was also a feeling that arbitrators tend to go overboard and are at times trying to make an interpretation of the policy which is not a standard interpretation. And as an insurance company, there was no avenue to challenge it. The scope of challenging an arbitration award being very, very limited. So these were some of the concerns, but as there were not too many arbitrations, so I cannot say that this is something which was formed over a very large sample size. As far as the ADR part is concerned, well, I think what you refer to by ADR is that alternative dispute resolution outside court. Please correct me if my understanding is correct.
Yes, sir.
Okay. So outside court, if you consider an ombudsman or a consumer forum to also be a court, there were very few occasions. I would really remember any where a kind of resolution was made uh, by any alternative dispute resolution method. Uh, in fact, as an insurance company, we had definitely undergone through alternative dispute resolution in our reinsurance recovery matters. There, the overseas reinsurers were involved, where uh, a conciliation or an arbitration is quite common. So we, in fact, were beneficiaries of ADR. Another alternative dispute resolution method that we had internally was the grievance redressal. Now, uh, it is strictly an in-house affair, and Masood, you were also involved in it. So uh, there, uh, a lot depends on how sensitive the insurance company is to uh, empathize with the aggrieved party. And there, my experience in the 4 years, and Masood, you also would have experienced the same, is that in spite of being empathetic, there was a lack of empowerment. Like this redressal cell was not able to, uh, even if it considers that some wrong has been done, it was not able to overdo and uh, the decision of the department which has done it, because it was not empowered to do that. And there were occasions when negative results uh, had been amended, corrected, and a decision in favor of the client was taken. But that again is far and few. So, without any empowerment or without any kind of authority, which also empowers the departments who are involved to reverse their decisions or get it reversed at a higher level. I think this grievance mechanism that is within the companies uh, is may not be able to meet the expectation of our insuring public. Uh, but I am quite happy to say that at least my experience with Oriental was that we were able to redress grievances to a very large extent. If not reverse the decision, at least explain to the client that whatever was due has been paid, and there is no injustice done to them. I think this is all that I have to say, Masood, on this. Thank you very much.
Thank you, sir. Thank you very much. You have made things very clear, and the attitude of the insurance companies as regards arbitration, and that's very much a fact. I believe all the insurers will agree who are present today. I'll now take this opportunity of putting a question to Mr. Vijay Srinivas, who is also a Director General of ASEAN Center for Dispute Resolution. So we're directly looking after arbitration cases which will be coming to ACBR. My question is, having served as the Director and Joint Additional Charge CMD of a public sector insurance company, how do you feel the benefit the public sector insurers will have in resorting to arbitration for insurance dispute resolution? I hope my question is clear, or should I repeat it?
No, it's clear. And quite interesting too. You want me to go back to my days of service and recollect what could be the possible implications. Yeah, it's interesting because the first thing I would feel is looking at the systems which are prevailing in the PSU insurance companies and also the aspects with regard to litigation when it goes to courts or consumer fora or whatever. I would feel that speed is one element which gives arbitration a major advantage. I'll just briefly highlight. See, what happens is in a PSU insurer, there is frequent movement of people from one desk to another, from one table or department to another, because of certain norms which are set in. So every 3 years or 2 years or 3 years or 4 years, people keep rotating. Now what happens is in a court case, the case drags on for years, sometimes years together, and so is the case in consumer forum and others. So what happens is the person who started the activity, he would no longer be there to see it conclude. And in between, a lot of things would have happened. The understanding of people who come as replacement, that would all change, and automatically there would be, the case would not get acted upon properly, defended properly, or taken up properly by the insurers themselves. So arbitration offers a quick resolution, and there's every chance that the person who started would probably continue to see it to its conclusion. So that's one major advantage, that continuity factor and speed of settlement in arbitration. That would give an edge over other forms. The second thing would be, of course, that the confidence that you are appointing your own judge, at least part of it. And that confidence that the person whom you will be appointing would understand the insurance process, because this is something which is a common complaint of insurers, that, when it goes to court, the deciding person is not, the things have not been highlighted properly and to that person, and they don't understand nuances of insurance, which again is a complicated subject. So that thing gets taken away, and there is a person in whom there is confidence, and person who would perhaps know the subject to be, understand the import of the dispute. And then, of course, one of the most important things is finality of awards. Because once there is it goes through an arbitration process, the award given is final. There's no further litigation. Unlike if it goes through other fora, it can go on and on and on in appeals and counter appeals and things like that. So my understanding is this is something which needs to be taken up by insurers. A serious look has to be given, and PSU insurers especially. Since you asked me about PSU insurers, I think these are certain distinct advantages which give this arbitration a major advantage over other forms of dispute resolution. And they should take a hard look at it and see how it can be made better and work better. I hope that gives some clarity to what you had asked.
Yeah, surely. Thank you very much. You have kind of explained the whole process. I hope insurers do take note of this. Thank you very much. I'll now be requesting Mr. Amarjit Singh Bedi, as a practitioner in the field of litigation and arbitration. What are your views on the pros and cons of institutional arbitration vis-a-vis ad hoc arbitration? So, I hope I'm clear. So should I repeat, sir?
Yes. Thank you, Mr. Wahab. Thank you for giving that brief introduction about me and the kind words about me being the youngest panelist here. I really appreciate that. As Justice Nageshwar Rao and Justice Hariprasad a few minutes ago gave a brief about the pros and cons of ad hoc and institutional arbitration, I would not want to repeat, and rather give my experience and practical examples of, as a lawyer, what I have come across and how I have felt about the practicality of ad hoc, as well as advantages, disadvantages of ad hoc vis-a-vis institutional arbitration. And I have 3 examples to give, which I did some of these matters, and from that experience, I'm coming forward. So, as all of you know, most of us have taken a car or something on hire from a financial institution. So I represent in many cases Tata Motor Finance and Mahindra Finance, etc. So these finance companies have a standard loan document, and if you read the fine print, it's a thick booklet with about probably 500,000 clauses in it, and somewhere in the middle you will find a clause regarding arbitration. Now, these arbitration clauses are very standard. They are not institutional at all. The complete discretion is with the financer. So they will select the venue, they will select the arbitrator, everything is under their control. And 95% of the cases, they are able to pull it off because people who default in repaying the EMIs do not resort to approach the court, as more or less the agreement is watertight and in the favor of the financer. So you don't have much of a defense when you default on 2 or 3 installments and they appoint an arbitrator. For example, if you have a Mahindra Finance loan, the arbitration venue is in Mumbai. So even if you have taken a loan, let's say in Karnataka, the arbitrator will be sitting in Mumbai and you have to appear before him. Now, an EMI of an average car is, if you're taken for 3 to 5 years, it's about 20 to 40,000, between 20 to 40,000. And if there are 2 or 3 defaults, then it's about 60,000, 80,000 rupees, for which a loan is recalled and arbitration proceeding starts. Now, as a borrower or as a consumer, I have a right to challenge it. I have a right to get a neutral arbitrator appointed. I have a right to contest that arbitration and have my day in the court or before the arbitrator. But 2 factors make a difference here, because the amount is very small. B, the agreement is usually so watertight that you don't have a defense. Even if you manage to get a neutral arbitrator appointed, you still cannot get much of a difference in the outcome. And therefore, most of these default arbitrations are decided between 1 or 3 months. A notice is sent, there is no claim, there is no response. The arbitrator gives one more hearing. Thereafter, he hears the claim, which is a standard format claim of the claimant, which is the financer, and he passes an award. And once an award is passed, if you have to challenge that award, you have to go to the court, you have to pre-deposit, etc., etc. So more or less, they execute the award by repossessing the vehicle and selling it off. And if there is still some difference, they can go after the borrower and try to recover through other means. So we're not getting into it, but the experience that I'm trying to share here is that in cases where the amount is small, where there are routine defaults, where agreement is watertight, institutional arbitration doesn't make sense for one of the parties, which is the financer, because there is a cost involved. They have their own panel of lawyers who are doing day in and day out all these arbitrations. They know what order to pass, what to say, how to complete tick the check boxes and make sure the award is more or less reasonable and fair when somebody reads it in the court. So that's one example of ad hoc arbitration being more viable, more practical even in today's day and age when it involves matter like this. And same probably goes for consumer finance. When somebody takes a loan to buy a refrigerator or a TV or a iPhone or a mobile or something like that, probably the same logic goes. Now I'll give you a second example where institutional arbitration made more sense, and that is one of the cases I did recently was where we had a Swedish client who had a suppliers agreement with India, with an Indian party. And we put the Delhi International Arbitration Center as the institutional arbitration center, which will deal with the commercials if there is a dispute. Now, lo and behold, after 2 years during COVID, things did not went well and there was a dispute. So our client invoked the arbitration and we went to Delhi International Arbitration Center. So I'll give you practically what happened there and how quickly the things were resolved. So immediately the arbitration center sends out a notice. You can see the rules and regulation on the website of Delhi International Arbitration Center. The fee schedule is already fixed. There is a panel of recognized and very excellent arbitrators, if I can say that. You can select, the procedure is you select 3 names and you send it to the arbitration center that we want to invoke arbitration. Party B is the defaulting party. We are selecting these 3 names and they give the names from the pool of arbitrators. The same mail is sent to the other side. They are also required to select from the pool of arbitrators. And once they select the names, if there is a common name, that gentleman is appointed as the arbitrator. And here Justice S.N. Dhingra was the common name, so he was appointed the arbitrator. First day we got notice, we filed our claims, they filed a counterclaim, timelines were fixed, all the proceedings and pleadings were completed within, I think, 1.5 months. The first hearing we had was an effective hearing when issues were framed and date was fixed for leading evidence. In 2 more dates, within a span of 15 days, the entire evidence was completed and he was ready to pronounce an award. Fortunately for us, the parties settled before the award was pronounced, but the entire exercise was completed within a period of 3.5 months, if I'm not wrong. And our clients were very happy and impressed with the speed at which arbitration, it led to a resolution for our clients. So that's an example of how institutional arbitration is so much recognized and it is so much convenient and better right now in given circumstances. So to answer your question on pros and cons, it is in the nature of dispute, the quantum of dispute, and the kind of clients you have that decides what you need to put in the arbitration. I hope I am able to answer your query on the advantages and disadvantages.
Very much so. Very much.
Thank you.
I mean, through your examples, you have really made things very clear as regards ad hoc and institutional arbitration. And I mean, taking a cue from you, I'd just like to say that ACDR, that is our ASEAN Center for Dispute Resolution, may be the only institutional arbitrator which can claim to specialize in insurance at least. Thank you very much for this first round. Even though we are slightly short of time, but this time we'll very quickly go through the second round. And I'll put the first question to Justice A. Hariprasad. Sir. Sir. Justice A. Hariprasad, sir.
1 minute. Okay. I'm here, able to hear you, Mr. Masood. Yes, sir. Please.
So this question to you, sir, in the second round, we'll try to do it quickly.
Yes. Yes.
So in your vast experience, what would be the approach of courts to institutional arbitration? Would they be more exacting in the scrutiny or such awards or continue the largely hands-off approach through strict interpretation of clauses for setting aside and review?
Okay.
I hope I'm clear, sir.
Okay, the question is clear. I'll answer it. Now, I think before answering that part of last part of the question, I think we just remember one fact that the arbitration as a device in the ADR mechanism, alternative dispute resolution mechanism, it stands apart because negotiation, mediation are where the parties are able to discuss things, try to sort out by themselves. They may be negotiation, there is only difference is that without even the intervention of a disinterested third party, you can go for negotiation. But in the case of a mediation, there is a professional mediator and what you call there the parties themselves can sort out. But in the case of arbitration, the pointed difference is that the arbitrator is an impartial private judge selected by the parties. And the arbitration, once an award, it culminates in an award, it can be unsettled by taking recourse to the award as provided under Section 34 of the Arbitration Conciliation Act. Section 34, as everyone knows, there are 7 grounds for interfering with an award, out of which 5 are factually factual grounds. I call it like in that way, or rather grounds which the parties complaining against the award must plead and prove. Whereas 2 grounds are the legal grounds on which the court can consider with the available records. So Section 34 jurisdiction, because I was a district judge for a long time and a High Court judge for about 8.5 years. Now, in my experience, the institutional arbitration has an edge over the ad hoc arbitration, because the institutional arbitration is done in an organized manner. And of course, some institutions have a what you call committee to scrutinize the nature of the award before all the flaws review possible. But in the case of an ad hoc arbitrator, what happens is that it depends on the subject knowledge, the attitude, the ability to translate the decision-making process into the award. These are all matters vary from one individual arbitrator to the other individual arbitrator. So chance of flaws, as in my experience, is more in the case of ad hoc arbitration. But of course, the flaws, all flaws falling outside Section 34 may not be a reason to set aside the award, that everyone knows. But then Section 34 will be normally attracted if some element, some vital element is missing in an ad hoc arbitrator who is not well versed in the subject, because the parties may agree on an arbitrator thinking that he's a person of some experience, some legal background or some technical background, depending on the nature of the case. Suppose he falls short of the expected standard, there could be a pitfall. But in the case of institutional arbitration, the advantage the higher courts per se find is that there will be a panel or pool of arbitrators from whom the institution will select for deciding or passing an award in a particular case. And there is every possibility of having more certitude or what you call accurateness in this matter. So generally speaking, it's not a what you call, it's too general a statement. It's not in all cases, it is not like that. Generally, institutional awards are favored, or rather interfered, unless it is shown that it falls within any of the limbs provided under Section 34, any of the 7 limbs. But in the case of individual arbitrator, ad hoc arbitration proceedings, the experience shows that the chance of interference is high because of the lack of dexterity or lack of what you call ability, acumen, whatever it is, of the arbitrator, individual arbitrator concerned. But as I told you, Section 34 is very strict. But you will find a lot of Supreme Court decisions on this point also, that Section 34 cannot be lightly invoked, because all the questions that should have been raised before the culmination of the award cannot be relegated to the Section 34 stage. So that rigidity is always there. But then, despite that rigidity, chance of interference is more, in my view, in the case of ad hoc arbitration. That's my view on this question.
Thank you, sir. Thank you for making things very clear, sir. I'll now put the question to Mr. Vijay. Mr. Vijay Srinivas.
Yeah.
As far as the arbitration system in stock exchanges seems to be working well and has virtually eliminated litigation in matters pertaining to stock exchange, what are your views about such a system for insurance disputes as well?
Well, that's an interesting question. I wouldn't say that I'm very well conversant with what's happening in the stock exchanges. But yes, it is definitely true that we have seen come a long way from the 80s and 90s, when stock exchanges used to be, there used to be a lot of issues and things the exchanges themselves would be held up for long periods of time. Two things which come to my mind from whatever I know about how the system operates. One is perhaps they have put in place arbitration system whereby parties, there are panels and people can approach them, and they're all experienced and they are told how to do it. Second thing is perhaps there are systems in place on how it is to be done and what is to be done. They have codified a lot of things. Third thing would be that I think the operations, stock exchange operations, are all very detailed. Detailed instructions have been given, and violations of that would be easy to place. And perhaps fourth is that the group involved are also a kind of a homogenized, a more homogenized system than what you would find in insurance, where insurance is a very disparate group of people, from totally illiterate to highly literate person. So it's a wide range. And the products in insurance are also vast, quite different, and even insurers themselves have a tough time understanding what it actually is. And procedures are not standardized. Each company, each product has a different procedure altogether. So, but it's not as if insurance can not bring in a system of systematized arbitration, as it has worked well in the stock exchanges and SEBI and other places. Perhaps a similar thing can be worked out here also by codifying a lot of things, a lot of procedures, and also ensuring that things move fast. But there's a long way to go. We are not in that stage. We are still in the process of understanding what arbitration is and how to go about it. And all said and done, only a small portion of insurance business comes up for arbitration. So that's where we are placed.
Thank you. Let's hope for the best.
Yeah.
Mr. Niraj Kumar, sir.
Yeah.
Sir. Mr. Niraj Kumar.
Yes, Masood.
Sir, your camera is off.
Now it's on.
Yes, sir. Thank you, sir. So with the regulator shifting emphasis from file and use system of product approval to the use and file system, can we expect the insurers to proactively have an expanded arbitration clause or speedier grievance redressal rather than continue with the same old quantum dispute being referred to arbitration? Is my question clear, sir? Should I repeat?
Yeah, it's quite clear. See, file and use or use and file doesn't make much of a difference, because it's only how do you use the product after approval or simultaneously with filing. So if there is intent to have an expanded clause, it's for the insurance company to file a product with that expanded clause. IRDA, I do not think would have any issue with an expanded clause. In fact, IRDA would most probably welcome it, considering that they are an institution which has to primarily protect insurers' interest. But I do not know till now if anybody has filed a product where we have an expanded clause. But expanded clause or otherwise, a claimant who has the resources has been able to go to court and get an overriding decision, and even matters of liability have been, as per court orders, been drawn into the ambit of arbitration. We had seen some cases, and I think now they are increasing. So it is, if the filing part of it is concerned, it is basically on the intent of the insurance company. That's it.
Thank you, sir. Thank you very much. I hope that things do improve as far as the law is concerned with this use and file thing now. I have the last question in the second round for Mr. Amarjit Singh Bedi. What, in your view, is the scope of experts in institutional arbitration in the specialized fields like insurance, construction, etc.? Do you see them staking their claim over by existing system of arbitration being largely dominated by retired judges or practicing advocates?
As Justice Nageshwar Rao said a few minutes back, that he himself feels that there is a big need for specialized arbitrators, and especially in field like insurance, etc. And again, I go back to my experience where I can tell you that where specialized arbitrators are a must. And one of the examples is I am a counsel for NHAI. And as you know, NHAI has all these contracts which are of thousands of crores. And usually all these agreements have a set formula that if the total quantum is more than, let's say, 1,000 crores, then it will be a panel of 3 arbitrators. And there is one interesting clause in NHAI contracts, which is that the arbitration will be governed by Sarod. Sarod is a society, it's an NGO set up by NHAI in collaboration with the National Highway Builder Federation. So Sarod stands for Society of Affordable Resolution of Dispute, and it has 8 members. 4 are from NHAI, 4 are from National Highway Builders Federation. And then there is a panel of arbitrators. Now, what is interesting is, and this may come as a inspiration to ACDR, is that there are total 98 arbitrators impaneled in Sarod, out of which there are only 8 judicial officers. The remaining 90 arbitrators are either engineers or bureaucrats or people who have domain knowledge. So NHAI feels, as well as the Builders Federation feels that in these disputes which are highly technical, there is role for the specialized arbitrators rather than judicial arbitrators. But obviously, when there are panel of 3, usually the presiding judge is a judicial member, and the other 2 are experienced or specialized members. But just to give you an example that yes, there is a need and there is a recognition. And a very good example is NHAI, which is dealing with thousands of crores of contracts every month, every year. And they have this thing in place called Sarod. So perhaps that answers that there is a need for specialized arbitrators rather than just being a judicial member.
Thank you, sir. Thank you very much, Mr. Vijay. I hope you must have taken note. And maybe you will look into this thing again, especially this concept of Saroj. And I am sure that this will give heart to all the participants of first, second, and third batch, that their qualification and their experience counts. So, thank you very much for the elaborate and very precise and very enlightening answers provided with all our panelists. I was looking for some questions for the panelists from our participants.
Sir, there is one question which we can address to Justice Hariprasad, indicating whether the financial sector regulator, in this case IRDA, can it be given the role of regulating the arbitrators also? Act says that arbitral institutions and other things are there. So can the regulator be entrusted with the responsibility of regulating the arbitrators in that particular domain? So that's some question which I feel will be useful for the participants.
No, my view about that question is, regulator, of course, the problem as pointed out by Justice Nageshwar Rao, as in the case of Singapore Arbitration Center or Thailand, there appears to be one center. So other countries are there. The credibility is the issue. If the regulator is able to set some standards, and if they are able to provide what you call some sort of nobody can be sure of the result, but everybody should be sure of the procedure and the reason which prompted to arrive at a decision. That is very important. So I'll just explain one, as Mr. Bedi has pointed out very vital things in a beautiful way. Because see, as he pointed out, you say you have a panel of arbitrators of which only one judicial member and other 2 technical members. That should be the way in which it should be constituted, because you will find decisions by the Supreme Court that the award need not be akin to a judgment in a case, because judgment you have to understand the facts, you have to raise the points to be decided, you have to answer the legal and factual questions raised, and you should give the reasoning, because every judgment is supported by, it should be supported by reasoning. The strength of every judgment is the reasoning, and through which or by which you arrived at the finding. But in the case of arbitration, probably that requirement is slightly watered down, because there are a lot of technical issues involved. It's not like what you call contesting a case under the provisions of CPC or CRPC or Evidence Act. These all procedural nuances have been taken out. So if that is considered, and if this this institution can provide a credibility to the the reasoning process and the award committee. Pardon? Sorry. If that is assured, probably there is nothing wrong in my perspective to appoint someone to regulate the proceedings.
Yes, sir. So there is another question which I would like to pose to Shri Amarjit. One of the participants is indicating that it takes around a year's time, then there is a scope for challenging the award, and then there is a provision for appeal against the decisions, etc. So when the accessibility of this forum is some other thing. So when the district court by the side of my is available for me, why do I choose arbitration as one of the questions? So being a practitioner and being a person who would be advising customers, so what would be your take on this, sir?
See, the biggest problem with going to courts is, apart from the issue of court fees. For example, if in Delhi you file a suit, a commercial suit, you have to pay court fees of approximately 1% of your claim, which goes to the court straight away. Then you have a lengthy litigation, and you have a forum which is exactly where the courts are situated. You have to be there, and it also depends on the total pendency of the judge. But here in the present case, when you are going before an arbitrator, if it is an ad hoc arbitration, you can even settle the total amount which has to be paid to the arbitrator as arbitrator's fees. Second, the venue can be decided by the parties. So if you are living, let's say, in Hyderabad, and the other party is living in, let's say, in Chennai, you can decide amongst yourself that we can have a common venue where we can go. If you go in courts, then you are wherever the cause of action has arisen, you have to go for that jurisdiction. That is the second. Third, the docket of, if you see the latest pendency, it is going in years now. An average suit is not decided before 5 years. Now, after the 2015 amendment and the latest 2019 and 21 amendment, now what the law says is that from the date pleadings are completed, within 1 year, your award has to be passed. So you are getting a finality, you are getting a deadline, you are getting your award in your hands within 1.5 years. And thereafter, the process of challenging the award, etc., is there, because even if you get an order or a decree from a court, you can still appeal, you can file a first appeal, a second appeal, and go to Supreme Court. So all those legal opportunities and remedies are available, whether you go to a court or you go before an arbitrator. But at least you get your original decree and award. The second biggest advantage now is, in view of the amendment, that if you want to challenge an award, you have to pre-deposit, which was not there earlier, and your award can be executed straight away, which is the problem with getting a decree executed. If you have a decree and you want to get a recovery, you know how difficult it is. Your problem starts after you get your decree. So in that sense, I feel that in commercial disputes specifically, arbitration is a much faster method and mode, much cheaper and efficient in that sense. If you look at the longer picture, the entire periods in which a case is decided, then in that sense, arbitration is much more cost efficient.
Thank you, sir. Thank you very much. I feel we cannot take any more questions, Dr. Mallikarjun,
yes,
because of the time constraint. So we'll be moving on to the last stage of the webinar. I'm very thankful to all the 4 panelists. I'm very thankful to Justice Hariprasad for giving us his time and on the subject in a very fine manner. I'm very thankful to Mr. Niraj Kumar for being with us despite his personal emergency at home. Very thankful to Mr. Vijay, Srinivas for being here with us, and I hope that he will take up the issue of Saroj also and do a comparative study. And I'm very thankful to Mr. Amarjit Singh Bedi for being with us and elaborating on the subject. need for arbitral institutions. So I hope that after this panel discussion, the verdict is out. And all the people, I don't have to say anything on that. All the people who are there in today's webinar, they can decide for themselves. And all our speakers have been very clear in their views. So once again, a very big thank to you on behalf of my personal thanks, as well as on behalf of ASEAN Institute of Insurance Risk Management, on behalf of ASEAN Arbitration Foundation, and of course on behalf of ASEAN Dispute Resolution Center. Thank you very much.